review of the events. There'll be plenty of time to parse, analyze, digest the events today. Our form of government has always been and will continue to be an example to the rest of the world. It's hard to imagine right now. The bedrock of a democratic society is the criminal justice system. And sometimes it's slow and it's always imperfect, but it works. So we're going to see that unfold in the coming weeks and months. But right now, we have a great opportunity to get an inside view of one aspect of that system from an expert in that particular topic. Our daughter, Marissa Goldberg, served as the Special Deputy Assistant State's Attorney beginning in 2013 and has served as Assistant State's Attorney since 2014. She prosecutes misdemeanor and felony cases, including negotiating criminal case dispositions, conducting evidentiary hearings, reviewing search and arrest warrants, and researching and drafting legal memoranda. She prepares and conducts jury trials, including selecting the jurors, arguing motions, conducting direct and cross-examination of witnesses. She serves as the GA11 representative for the Wyndham Multidisciplinary Child Abuse Team and for human trafficking cases. She has successfully argued an appeal before the Connecticut Supreme Court. She earned her Juris Doctor law degree from William & Mary in 2013. She was the managing editor of William & Mary's Journal of Women in the Law, and she served as president of the Northeast Law Society. And before her law studies, she earned a Bachelor of Arts in Political Science and a Master of Arts in Judaic Studies, both from UConn. Marissa, thanks for presenting tonight.
Thank you for that introduction. One clarification, so I did just transfer to New London from Wyndham back in June. So I am transitioning down there and now doing their human trafficking work as well as on their multidisciplinary team as well. So let me see if I can get my screen shared here. Can everybody see that? Okay. So before I get started, I just want to give credit where credit is due. Portions of this slideshow and my remarks are borrowed from a presentation that former Chief State's Attorney Kevin Kane gave a couple of years ago when he was reporting back to the legislature on the early screening and intervention program, which is the ESI program. So before I jump into the ESI program and what that looks like and what that is, I just want to give a brief background of the criminal justice system and how we kind of work from arrest through conviction or disposition of a case. So in Connecticut, we operate a little bit differently than some other states do. So in Connecticut, our police make an arrest. There's two ways for them to do that. The first is by warrant. So what that means is when somebody is arrested at a later point in time than when the crime was committed. So for example, if a crime is committed on a Monday, so say somebody beats up a person at a bar on a Monday, police get called, but the person has fled the scene. The police have to do maybe a day or two of investigation, looking into who was there, getting surveillance video. That person might not be arrested for a couple of days. When that occurs, they submit a written warrant to the court. The prosecutor, either myself or one of my colleagues, would review that to make sure that all the elements of the crime are met. And then once we sign it, a judge signs off on it, which starts the criminal proceedings in court. The other way that people come to court is an on-site arrest. And so that's the situation where somebody's stealing something from, say, Walmart, and the loss prevention officer calls the police. Police respond before the person has left the store or while they're still in the parking lot. They're able to do their investigation right there, and they're able to arrest the person without ever having brought the case before a prosecutor or a judge. You can see where the problems might lie in that, is that if somebody was arrested and maybe shouldn't have been, or maybe all the elements of the crime weren't met, that can occasionally be a problem. So either way, when a warrant is served or when somebody is arrested on site, the paperwork goes directly to our criminal clerk's office, and the clerk adds the case onto our daily docket. We don't ever have a chance to review it at that point in time. It gets added on. It then gets called in court in front of a judge where the proceeding occurs. A lot of other states have a prosecutor in there as a way to filter the cases through, or they have grand juries to make sure that if somebody's arrested, that it's the right type of case to have an arrest on. So there's a lot of built-in checks and balances in other states that Connecticut doesn't always have in a lot of its cases. And so once a case gets to court, a person would appear before the judge. If they need an attorney based on the type of case, if it's too serious for them to go through the process on their own, if they're likely to end up with a conviction, we usually recommend that they talk to an attorney, either a public defender or a private attorney, depending on their income level and what their means are. We usually have to do a discovery process. What that is providing all of the paperwork in the case, all of the evidence, photographs, video, over to defense attorneys. Again, either a public defender or private attorney. Occasionally, pro se, which is self-represented parties, will apply for the discovery themselves. And so that takes occasionally a couple of court dates. And then we get into negotiating the case. That can take anywhere between 1 court date, 2 court dates. Some cases stay on the docket for a year or more, depending on how complicated they are, if there's follow-up investigation that needs to be done. And at that point, there's either a nollie, which is us dropping the case for whatever reason, whether somebody went through a program, got themselves some treatment, or a conviction of some sort, so a guilty plea. Or a trial. And especially right now, our dockets are incredibly backed up, trying to limit the number of people that we have coming into the courthouse each day. Criminal jury trials are on hold for the moment, so we're just not moving the cases that we were previously. So going back to the charging decisions and whether it's by warrant or an on-site arrest, when an on-site arrest occurs, it has a lot of different consequences that filter through the system. So the first is having too many continuances. And so when an investigation is able to fully take place up front, we generally get everything that we need beforehand. So when I get a warrant to review, I sometimes send it back to the police department and say, okay, you know, I appreciate the work that you've done on this. I'm still looking for X, Y, and Z because these are the items that I would need to make my case stronger and that I'm going to need to actually prosecute this case fully. Again, with an on-site arrest, we sometimes have to do that investigation after the person is arrested, which results in a lot of delays. There's also over and undercharging. So for example, I had a case this morning. The person was arrested, and when I'm reading through the report, it indicated that the individual actually injured a police officer during a struggle. Police charged it as an interfering with arrest, but we also have a charge that's an assault on a police officer, and they didn't charge the assault on the police officer, and so that's something that after reviewing it, I was able to add, but might be addressed, you know, sooner on. If we actually have the opportunity to review it. Overcharging, sometimes officers will look at what the actual elements of the crime are and decide, okay, we have enough to prove, you know, say a home invasion, which is one of our more strenuous charges, which has a lot of different elements to it. And that it may fit, but based on, you know, mitigating factors, the relationship between the parties, any number of things, we may decide, you know, it's really more of a burglary. So both require entry into a residence of some sort. They can both involve injury to the parties that are involved, but home invasion is a much more serious crime that we generally reserve for, it came about after the Cheshire home invasion cases. And so we really try and reserve it for really strong burglary cases with very bad outcomes. And it carries a 10-year mandatory minimum, which is a very high mandatory minimum. And so our legislature also indicated to us that they don't want that used in every single case that it may technically fit. So the other piece of it is that everyone that's arrested is treated as a quote unquote criminal. And so they're not necessarily handcuffed and put in the back of a car. Sometimes they're released on a summons, which is essentially a ticket for a criminal offense. But they're still coming to court with our normal case flow. They're going in front of a judge and they're having to face a criminal charge. And so that can be, for some people, very demeaning and in and of itself punishment for what they've done. And the other piece of it is that we don't get a lot of treatment for any underlying issues that may exist. So you have people that get arrested, come into the court system, and are either held on bond because of what they've done, or if they're released, we're really just addressing the criminal charge. We're not addressing any of the other issues that may be at hand. So Connecticut recognized this as being an issue, and they instituted the early screening program. So this was instituted in 2017 by the legislature, but it was after a lot of lobbying by some community providers. It was an act establishing a pilot program to provide enhanced community services to those in the criminal justice system. So the pilot programs were launched in Hartford, New Haven, New London, and Norwich. And the idea was to screen people, low-level offenders, so no one that's done anything violent or really serious, but wanting to make sure that we address what the issues are. So homelessness, drug addiction, mental illness, and get them some treatment if it's appropriate. And so the idea is that we're getting in at the ground level. So we're able to address these cases sometimes before the person ever shows up in a courtroom. We're able to get in and divert them away from the traditional criminal justice path and see what we're able to accomplish in terms of the diversion piece of it. So there's two different components to the ESI program in Connecticut. So the first is the prosecutor, and I'm the ESI prosecutor for New London County. And so I screen the cases to determine if, can the case be prosecuted and should the case be prosecuted? And so the can the case be prosecuted is the elements of the crime. So it's looking at, are we able to actually prove this case? So for a larceny, making sure that I have an intent to deprive someone of property. So did this person just borrow something from a friend that they intended to return? Or did they take it and they're going to hold on to it and not give it back? And then the second element for larceny would be that they actually took it. So did they actually get their hands on it and leave with it, or did they decide, man, I'm not gonna take it with me? In which case we wouldn't be able to prosecute it for a larceny. The bigger piece is for should the case be prosecuted. And so the idea being that we look at these cases a lot of the times, and the person has been arrested for an assault or a breach of the peace or something, relatively minor, no major injuries, the victim's not upset about it or doesn't want prosecution. And really this person has a lot of problems that are not being addressed, that it's maybe not equitable and just to actually have the person prosecuted and ending up with a criminal record because of what they've done. So I'll give you guys a couple of examples. So I had a woman she was 57 years old. She was arrested for a larceny in the 6th degree for underscanning merchandise at a chain store in the area. So it's a minor crime. Larceny 6th degree is under $500 of merchandise stolen. It only carries up to 90 days in jail if you're convicted. Generally speaking, even if you are convicted, we are not sending people to jail for petty larceny. And what she was doing is she would fill her cart up or on this particular occasion, fill her cart up with items, go to the self-checkout line, and she was scanning only every other item or every third item or something along those lines, where she's putting things into her bag that had not been paid for. She had no criminal history, 57 years old. She's made it through, a good portion of her life without ever getting arrested, ever having any interaction with our system. And we learned from talking to her that she got furloughed from her job because of COVID. And so she was out of work and she was struggling. She was not being able to make ends meet because of the current situation. And when her job did get ready to call her back, they told her that she couldn't go back to work because she had a pending case. And so she was really kind of in a bind where she's looking at, what do I do? I'm stuck here. I can't work because of this case, but the courts are, kicking these cases out month by month, and I'm not able to go to court on it. So she had called and basically asked if there was any way that we could resolve the case. And she had indicated, I'll plead guilty if I need to. We looked at it and decided, yeah, we can prosecute it. We have her on video, taking the items from the store. She admitted it to the officers when the officers got there. She was apologetic about it. And the real question is, should we prosecute it? And so, I always look at who will benefit from this person being prosecuted. And really, in this case, no one benefits. The store didn't have any items actually lost, so that she was stopped in the parking lot. The items were all recovered. They trespassed her from the store, so she's not allowed to go back there in the future. So their interests are being protected and are being met. The woman is not really benefiting from it. She's horribly embarrassed already. She's never committed a crime before, so it's unlikely that she would do this in the future. And she really expressed to everyone involved that she had learned her lesson and that this was just a really poor lapse in judgment based on all the circumstances involved. And I also have to look at whether or not society would benefit from her being convicted. And in this case, I decided no, society's not, there's no reason for this woman to have a criminal record. She's better off going back to her job and working and contributing to society. And we as a society benefit from her not having a criminal record in this case. So she got referred into our ESI program. So once I screen it and decide that it's appropriate for ESI, the case goes to a resource counselor. So I upload all the information from the case into it's an intake form, and provide that to a resource counselor who's a social worker provided by some local agencies. And I have local capitalized because the local piece is really important. Local agencies are more familiar with the challenges that we face here in our community. They're more familiar with what resources are available and what resources are not available. And any money that's spent on our grant program through the state is also reinvested back into our local community, which was important as we looked at integrating and getting this program up and running. The other big piece, again, in terms of knowing what the local challenges are, different communities in the state have very different issues that they're dealing with. So when I was in Windham County, access to resources was huge. There was one bus line that ran from Willimantic to Danielson up to Putnam. And if you missed that bus, you weren't getting to one of those hotspots where we had providers. And most of the people didn't live in the downtown areas. We had people that were walking miles to get to therapy appointments, to get to treatment appointments. And that was a big issue up in Danielson. So this program's not in Danielson yet, but I know that that's one of the things that they're looking at and how to implement this program up there. Compare that to New London, which is sort of middle of the road. We do have a lot more access. We have more public transportation. We do have more providers as well between Norwich and New London. And then compare that on the other side of the state to Hartford and New Haven, where they're really, everything's right there. And obviously money's a problem for everybody, but there's definitely more opportunities for services in those areas. And so they're able to actually operate a little bit more broad programs up there with more people involved. So what does the resource counselor do? They provide a service needs assessment. So they do a full intake of the person, much like they would if somebody went to therapy for the first time, substance abuse treatment for the first time. They go through the person's history, their whole background, family background, work history, mental health history, substance abuse history. They really look at sort of comprehensive items that would help to either support this person as they move forward in their life, or that are really, drawing away from that and making it difficult for them to navigate in a daily life. Once that assessment is completed, they make referrals out to different service providers. So that may be for individualized therapy or for group therapy, for detox in some cases. If somebody comes in and they're actively using and need immediate treatment, they might get referred to a detox program. We've done inpatient treatment, outpatient treatment, pretty much every level we're able to do. In terms of transportation, we're able to provide bus passes a lot of the times to people to help them get to their treatment. I know that in other parts of the state, I think Waterbury has a program set up, and they are up and running really, really well. And they have like a weekly check-in where you're able to get access to like clothing and a food bank and everything all in one stop. So that they're really, it looks a little bit different in every court right now. And so that's something that we're addressing to see if we can get everybody kind of on the same playing field a little bit more. But we are definitely doing the best we can. So once the resource counselor makes those referrals, they report back to me. And so our resource counselor will make a referral, or in some cases, if the person comes back and says, you know what, it was like the woman before, it was a lapse in judgment, we might help them get access to, in her case, making sure that she has the funds, whether it be through a food bank or whatever the items, there are resources available for people to get, healthcare items and food and clothing in the community. And so we do our best to set them up with that, because especially for somebody like her, she maybe has never had to do that before and just doesn't know what's available. So occasionally we'll just make a referral in that way. So looking at another case study, this was a woman who also committed a larceny. She indicated to us that she was working 2 different jobs to support her family, including her disabled husband, who she was trying to be a caregiver to at home as well. She reported that she had never had any substance abuse or mental health concerns. And again, it's self-reported, so we're able to tell sometimes, just from the conversation with them, if it's a little bit more in depth, whether or not they're being honest. And if we have any concerns whatsoever, we usually send them for a referral and an evaluation, and just in case we're missing something. But she indicated that she committed the larceny because she was tight on money. Her grandkids were getting ready to go back to school. And again, with COVID and everything else going on, she was just really struggling. The recommendation from our resource counselor was that she didn't need any in-depth services. She didn't need substance abuse or mental health treatment. So our recommendation was to give her some resources for clothing for her and her kids or her grandkids. We also were able to give her some information about possible in-home services that might be covered under her insurance, to see if we could get somebody into the home a little bit more often to help her with her husband's care, and a few other recommendations as well. And then we recommended 20 hours of community service based on the quantity of items that she had stolen. And we felt that there was a need for there to be a little bit more than just giving her those referrals. So we're able to be really flexible with this in terms of deciding what somebody might need. And it's very, very individualized. Here's another one, a little bit of a different situation. So this kid was he was 18 years old, had no prior involvement with the criminal justice system. And he was in New London riding his bicycle down the street in and out of traffic, and just causing a scene. And then when the police got some calls on him and went out to stop him, he refused to cooperate with the officer. He didn't fight with him, but he was really kind of belligerent. And officers figured out very quickly that he was drunk. So he was highly intoxicated and ultimately was arrested for an interfering and a breach of peace, which is sort of our general, crime against the society. So for him, because there was an alcohol component associated with his crime, we did ask him to do a substance abuse evaluation and any treatment that's recommended. So we haven't, I don't recall whether or not any treatment was recommended for him, but that's generally what we'll do is have them do the eval. And if it comes back that they need some, treatment, then they're required to do it as part of this program. Similarly, if somebody's arrested for a drug offense for the first time or an offense related to drug use, we would have them do that substance abuse evaluation and see what comes out of that. We also always require them to stay out of trouble. So if they pick up a new arrest while the current case is pending, we obviously would take a look at it, look at the type of crime, see if we're not meeting their needs, if there's something more that we need to put into place, or if this is a person that's really not appropriate for this type of diversion. So the ultimate goal of ESI is to have a collaborative review of these cases. So we're trying to get the services in place, have the person's needs met, and dispose of the case with minimal court involvement. So if we never have to have them go in front of a judge, that is a good outcome for us. And we also want to make sure that if there is a service need, that the person is getting the assistance that they need to help reduce their future contact with the criminal justice system. So it's obviously different than what we normally, how we normally approach our cases. So we're individualizing justice. So we're looking at the impact of the crime on the community and the victim involved. A lot of our cases don't have an individual victim. It's often stores or society as a whole. When there is a victim involved, we always make sure to contact them and let them know what's going on with the case before we make any decisions with it, because obviously their input is required by law, first of all, but second of all, important in how we make our decisions. It's also individualized based on the defendant themselves, their background, and the underlying charge, and it's individualized based on the community services that we have available. It's also allowing us to do an in-depth review at the earliest stage of the court process. So instead of waiting 3, 4, 5 months to determine, okay, this person maybe has an issue here and we should be addressing it before we proceed, we're getting to the heart of that right away, usually within a court date, if not sooner, which reduces our court dates that we're we're before a judge, which reduce costs overall. So I personally really like this program because there's this, I think, view in society that a prosecutor's role is to put people in jail. There's actually, when a defendant, there's a concern about a defendant not understanding what's going on in the courtroom, they're asked a series of questions about whether or not they know what each person in the courtroom does. So what does the judge do? What does your defense attorney do? What does the prosecutor do? And the standard answer to what a prosecutor does is, she wants to put me in jail. They want to get me locked up. And that's frustrating for me because that's not the approach that I have ever taken with a case. If I can avoid putting somebody in jail, I certainly will. But there are cases obviously where jail is warranted and where it's that's the appropriate disposition. But I think if you ask most of my colleagues, if we had the resources available to us, we would often divert people into treatment and get them services as opposed to necessarily locking them up. So how is the ESI program working out in the state? So the data is a little bit dated at this point, but back in 2018, after the pilot programs were instituted, they saw that there were 10,000 cases that were accepted, or approximately 10,000, approximately 2,500 were accepted. So that means that the prosecutor sat down with prosecutors throughout the state sat down with 10,000 cases, reviewed them, decided that 2,500 were not of such a serious nature as to preclude it, and that the nature of the case and the nature of the individual warranted using this program. 89% successfully completed the recommendations, and 89% had 2 or fewer appearances before a judge, which is something that we are pushed on a lot in terms of how many times somebody comes to court, how many times somebody appears before a judge. Again, if a case pends for a year, figure once a month that they're coming to court, so that's 12 appearances. Not only is that 12 days that I have to stand in court and have that person appear and go through the background to the judge, it's also 12 days that that person is not at work, that they are not providing childcare to their kids. It's the impact on the person as well that we're trying to avoid. Right now, we don't have a great tracking system in place. So the Division of Criminal Justice, we don't keep our own stats on this right now. We have an Excel spreadsheet with about probably 25 different columns of information that we have to fill out. That data goes to, I think it's DDS, Department of, I'm sorry, I'm drawing a blank on which department oversees this, at the higher level, but they are the ones that administer our grants. And so they get the data just to make sure that we are using our grant money appropriately and that there's actually enough people being served by this program. And so the grant covers a lot of the treatment, but it also covers our resource counselor. And so their salary is paid by the grant so that they're able to work with us full time. The Division of Criminal Justice, just on a sort of side note, we just instituted a tracking system. It's an online tracking system for all of our cases. It is just now getting up and running within the last, we started it on Monday. So we are hoping that we are going to, once that's up and running, we'll be able to incorporate our ESI cases into it and be able to have a lot better data. And we are really hoping that this will be extended statewide in every jurisdiction throughout the state. There's also obviously the fiscal savings, and this is, legislature is looking at this, the grant providers are looking at this. So, beyond the assistance that it's providing to people, it's also a huge cost savings. So they're estimated that it's saving approximately $2,200 per individual. So that's in current services, future services that the person may need, court costs that the person may need if they come into contact with our system again. So making sure that they are not involved and they don't recidivate and come back to our system. So it's a large savings per person. And they did some calculations to figure out how many appearances would be saved, and they said that approximately 54,000 court appearances. And so that, again, one person coming to court 12 times a year times however many people gives us that figure. And it's freeing up huge amounts of court time as well. So not having to be in the courtroom. And we have marshals that have to be in the courtroom. We have a judge, a court monitor who takes the record, a court clerk, prosecutor, a public defender. So when you're looking at the staff and the cost savings there, as well as the less time that we're in court, means potentially fewer staff members that need to be either hired or can be using their time for something different. And especially with COVID going on, the reduction in court appearances and court time is something that they're really looking at, and they're encouraging us, even with all the challenges with COVID, to really push forward and see what we're able to do with this program, because they know that it's reducing the foot traffic in the courthouses. So, it's 2021, but of course we do have to discuss how COVID has affected our program. So the biggest things obviously are less court appearances and remote intervention. So what we're doing right now is I get a stack of cases on a weekly basis of people that have been arrested. I go through those cases. A lot of the times police departments will take down contact information for somebody at the time of arrest. So I'm able to provide that information to our resource counselor, and she's actually reaching out to people before they come to court, before they even have a court date, sometimes a month or two beforehand. And we're getting these services in place and talking to them and screening them ahead of time. So if we can never have them step foot in the courthouse as part of this, that's something that we're trying to do. And if we don't have a phone number, we're able to use our in-house systems to search for the person and see if we can get one. It's also presented a lot of challenges. So access to services is down. A lot of programs have gone remote, which is challenging in the fact that a lot of our clientele do not have access to the technology. So some of them are on state issued phones, which often don't have internet on them. They're not having a computer. If they have a computer, it's usually using the one at the library, or one that's really kind of either outdated or doesn't have the hookups to be able to link into a Zoom meeting or something along those lines. In person, if there are groups going on, they're significantly smaller. So whereas they might have been able to fit 50 people into a room for some type of treatment program, they're now doing 20 people. And so we just don't have the resources available. So unfortunately, right now, we're doing the best that we can to make recommendations for community service and really screening who truly needs the service versus who can maybe get by without it. And we're providing them with other recommendations if we're able to give those. And then administration of the program has been a real challenge for us. So my courthouse is GA10 on Broad Street in New London. Our courthouse is closed right now. It's been closed since May. We were working remote for a period of time, and then they have very recently moved us up the street to the Part A courthouse on Huntington Street. But our files are still in 2 different places. Right now, we are sharing 2 computers between 4 prosecutors. And so we're really, really struggling right now on a daily basis anyways. And then trying to keep track of all of these people and, getting our e-prosecutor, our new tracking system up and running. There's just a lot going on right now that's made it incredibly difficult to keep this running smoothly. And then we have staff turnover. If we have a day that somebody is exposed to COVID, we have people that are going out, and it's really, it's bumpy right now. We're doing the best that we can, but it's not ideal. And that kind of goes for the entire court system. So I think I talked through that a little bit faster than I was intending to, but I'm happy to leave plenty of time here for questions. I know that this is hopefully a topic that was interesting, and in terms of the criminal justice system in general, I'm hoping that most of you have not had interactions with it prior to this. And so I'm happy to answer any questions that you may have.
Marissa, Kathleen, could you please, there we go. That's what I wanted you to do, is stop sharing so we could see everybody. And so who had a question?
I do.
Okay, Barbara, go ahead.
Okay, let me find Marissa. There she is. Hi.
Hello.
Hi.
Good, how are you?
Good. My question is there any oversight after the program has been established? Do you follow these people to see if they're repeat offenders, or if this program really does scare them straight? Is there some kind of follow-up program?
Right. So it hasn't been in existence long enough, I think, to have a true look at that and whether or not it's effective. There's been studies done that getting people the treatment that they need ultimately does reduce their coming back to court and getting arrested in the future. But I've had defendants that have gotten the treatment. I had one person in Danielson that had, I think, 4 or 5 cases pending. He went to treatment. He did fantastic. He did 6 months at an inpatient treatment. He was like a model student. When he was released, he went to live with his parents. He lived there for 3 months, complied with everything that he was supposed to do. We gave him a fully suspended sentence, so no jail time, but he was on probation for a period of time. And he violated his probation within like 2 or 3 months by picking up a new arrest. And so it's really difficult to tell what level of treatment somebody needs and what the impact of a program like this will be long term. So we do follow them for a period while they're in the program. So until they've completed whatever the recommendations are, we are keeping track of them. And if they don't complete it successfully, their case is brought back to court and treated like any other case would be. I'm hoping that with our new tracking system in place that we'll get a much better idea of this and be able to actually go back and see whether or not these people are staying out of trouble.
Thank you.
Joelle, did you have a question?
Yes. Hi, Marissa. My name's
Hello.
Joelle Fernandez. I've worked for DCF for almost 21 years. I think we've passed like ships in the night because I've gone back and forth from New London County to Windham County 4 times in that 24 years. So I'm familiar with, both areas, certainly. I'm in the Norwich office now, which covers all of New London County. And I'm in a QA position right now, so I'm not on the front lines anymore, so to speak. So I don't have involvement with the MDT and that sort of thing anymore. But a lot of times, we're dealing with the same population.
Yes.
And many times there are expectations from the juvenile court in our cases where we've gotten the juvenile court involved, or when we've actually removed a child from that parent's custody. And it seems like a lot of times there's not a lot of communication between criminal court expectations and juvenile court expectations. So people have a set of what they call specific steps in the juvenile court that they're expected to comply with. And then they have things with the criminal court that they're expected to comply with.
Right.
And you know, I've seen clients get very frustrated, understandably so, because they said, well, you're saying I have to go to substance abuse treatment, but the criminal court says I need to go here and this, that, and the other thing. And I was just wondering if the resource coordinators for the program that you're referencing, do they coordinate with DCF to try to to not duplicate services?
Yeah, so a lot of the cases that we're getting for ESI are not DCF involved cases, because those are generally going to be our domestic violence cases, and those are not eligible for the ESI program, just based on the nature of the crime there. But we often have somebody who's involved in juvenile court with DCF, as well as maybe picking up a larceny or something like that with us. And so one of the screening elements that our resource counselor will do is, are you involved in any other court proceedings or any other state agencies? Our resource counselors don't have a great way to check that. So if somebody just lies to their face, obviously, we're kind of stuck. But if they're forthcoming with it, usually we'll be able to reach out either to the DCF worker or whoever the person is involved with, and verify what they're doing. And sometimes our recommendation will be comply with whatever DCF wants you to do. And that goes for normal cases, not ESI cases. Just if somebody's in the court system on a domestic case, that may be the recommendation, that DCF is involved. They have a good handle on the situation. They're wanting you to do everything that we would have asked anyways. And so we're just going to follow their lead on it. But it does happen fairly regularly that they're not on the same path. And that is frustrating, because I think
I was thinking, yeah, somewhat of the larceny cases too, because I mean, at least with the population I see, I would say upwards of 80%, maybe even 90% of the larcenies, the folks I see with larceny charges are opiate related.
Mm-hmm.
They're stealing something to support a habit. So I guess that's where, part of where some of that frustration comes in between the two systems, I think.
Right. And so if there's a child either in the car or with the parent or something like that, that'll get flagged on our case, and DCF is usually called on those. If it's just the parent out on their own committing that crime, we won't necessarily even know from our case that they have an open DCF case,
Right.
or that they have children, or that there are children involved in juvenile court or anything like that.
Gotcha. Thank you. Oh, yeah.
Okay.
Sandy had one too. Sandy had.
First of all, I enjoyed your talk, Marissa. Quite,
Thank you.
very nice and very challenging career, and good luck
Mhm.
with it. My question, and I know this was probably pre-COVID, more relevant. Do these people who are first-time offenders who don't have to serve jail time, do they get to possibly visit prisons to see what it would be like if they were incarcerated, just so that they can see what that experience would be like? Because that might not be a bad idea.
We don't have a Scared Straight program in Connecticut. I agree that it would potentially for a lot of these people would be beneficial to see what that looks like, and to walk the halls and get heckled by the inmates and things like that. But unfortunately, we don't have that right now. I don't know why we don't. I don't know if there's been, perhaps there's been studies done that it's not as effective as I think the people that are going to be scared of the system are going to be scared of the system, whether or not they walk into a correctional institute.
Thank you.
Go ahead. Chuck?
Hi, Marissa. Could you give us 2 minutes on how cash bail works in the state of Connecticut and your feelings about eliminating it for certain classes of crimes?
Yeah, so Connecticut right now, we're required to give a cash option on bail. So New Jersey just got rid of their cash bail altogether, or not just got rid of it, but I think that was a year or two ago. So the idea is that people that are low income are being held disproportionately for misdemeanor and minor crimes compared to people who have the means to post a bond. And so bail bondsmen in Connecticut often would not post bonds that were below a certain amount. So you were getting people that, perhaps it's $1,000 bond. The court would require like a 10% option or something like that. And so the bail bondsman would say, it's $100, it's not really worth my time. And so you get people that are being held on very low bonds for fairly minor crimes. So the best thing that I think Connecticut has done recently is we're required to review cases for misdemeanors if the person is still incarcerated on a like, I think it's every 3 weeks that they have to come back to court. And so we're making sure as best we can that, especially with COVID, we're not setting bonds for nearly as many people as we used to be. But in terms of our low level crimes, if they are held, they're being reviewed on a fairly regular basis. Our bond system is not something that we really get involved with other than asking for what the bond should be. And we're taking everything into account for it. So, it may look on the surface like somebody has misdemeanor crimes pending. So that's incarceration less than a year. But oftentimes they have a lengthy criminal history, or they have multiple cases pending, or they have failures to appear pending. And so generally, if somebody's held on a misdemeanor crime in Connecticut, there are extenuating circumstances that bring them into that position. But we are still trying really, as best we can to not hold people for crimes that are, of the more minor nature.
Harriet, did you have a question?
Yeah, I think, can you hear me?
I can't.
Yes.
Oh, good. I'm wondering, for instance, with your 18-year-old inebriated person, how much does their school record account for what you look at, or do you look at?
So we don't look at it all that much. We sometimes will make it a condition either of the ESI program if they were close to finishing school and that was something that they were talking about doing. We might recommend to them as part of it that they go back and get their GED, make that a requirement so that they are set up in the future for being a little bit more productive. Same thing when we put somebody on probation. If we have somebody who's maybe 20 years old and has been really just getting themselves into trouble, we'll make either full-time school, full-time employment, or a combination of the two as a condition of their probation, so that we're making sure that they're being they're contributing somehow, whatever that may look like for them, that they're involved with either school or work. We don't really look at it in the sense that, like if somebody's graduated from high school versus not, that the person who would have graduated would be treated more favorably. But it is a consideration in terms of going forward, what we might want them to consider and get help for.
And do you look at if they have a special ed background?
It's not something that I've run into, but I know that as part of the screening process, it's pretty thorough. It's the same screening process that would be used for treatment for mental health or substance abuse. And so I can certainly follow up. That's an interesting question. I would want to make sure that is part of the screening process to see what the challenges were.
Well, I just want an addendum. Every once I read the arrest record, and I'm a former New London speech pathologist, and occasionally I see a few of my former students on the arrest record who I know have significant language disability, not bilingualism, a disability. And I worry about them, Are they able to explain? Are they able to really give you insight into why they have done this? Because they do have significant issues. And I think it is something to look at.
Absolutely. And so when I talk to somebody when they come into court for the first time, I try to get an understanding of what happened. I always give them the opportunity to talk to an attorney first, because obviously they have that right. I warn them that if they tell me something that is, bad for their case, that I'm obviously able to use it against them. But then I give them the opportunity to speak. And if during that conversation, I feel like I'm not understanding what they're telling me, or I feel like they're struggling to tell me what happened, whether it be because of just straight up nerves, which happens for a lot of people that come into our system, or if it potentially is related to a disability of some sort, I will often recommend that they talk to an attorney or apply for the public defender's office, because I know that I want everyone to have a fair shot at the system and making sure that whatever they want to tell us is communicated well, and is they're given the opportunity to have their side of things heard.
Thank you.
Nadine?
Okay. Hi, Marissa. Mark Littman.
Hello.
I was just wondering, I had been on probation for almost 3 decades in New London, and I was curious to find out how the new program utilizes probation, and what aspects, if at all.
So we're not, we are pre-probation. So we're not using probation at all. These are not people that have not pled to anything. They're not involved in any sort of probation at the time. And so we're sort of setting up our own like mini probation, if you will. And so they are responsible for providing proof of whatever the requirements that we've asked them to fulfill. They're required for providing proof to that. So our resource counselor is not a babysitter. She makes sure that everybody has her contact information. She will follow up with somebody once or twice. I think by the 3rd time that she's followed up, if she hasn't heard back, she's closing out their case, or at least suspending it for a period of time. And so we, we're not using probation's resources. We're doing our own thing with it. So we're totally separate.
Thank you.
And I think Bev had a question. Go ahead, Bev.
I was just wondering, is there any provision for restitution to the victims? Say the stolen goods are found, do the victims get the goods returned?
Yeah, so on our intake sheet that I sent to the resource counselor, there's actually 2 boxes. One is there a victim? And 2 is what's the victim's position? And so for every single case that we have, if there's a victim involved, whether it's a retail store or an individual person who had a car broken into, or was involved in a bar fight or something like that, we are required by the Connecticut Constitution to make contact with our victims. And so a letter goes out to every single person. If they come back with whatever they want, so if it's a restitution claim that they have damage to a door, or restitution for something that was stolen, that is always part of our program. So we don't proceed with the ESI program unless victims taken into account, and whatever they are asking for is incorporated in some way, as long as it's reasonable.
I have a question. Is it always the prosecutor that identifies individuals for this program, or are there other points in the process where somebody else can? It's actually a 2-part question. And the second part of the question is, do you think Connecticut should go to a grand jury or a prosecutorial filter that you described in the beginning? Do you think that would help Connecticut to do that?
Yeah, so I'll start with the first one because that's a little bit easier. And now, of course, I'm drawing a blank on it. So the question, again, I'm sorry.
No, that's okay. Is it always the prosecutor that identifies?
Thank you. No, so right now it's primarily me that's doing it because there's just not enough information about the program out in the community. So the hope is that if we're able to get to our police departments and educate all of the officers, that an officer might make an arrest and flag it for ESI as, I arrested this person because they committed a crime, but I don't want them to go to jail. I want them to get services, or I think they need to get services. So we're hoping to have police start flagging cases for us if they're able to. The public defender's office in New London is well aware of the program. And so I've told them if they, I might miss a case, or especially with COVID and our cases being kind of all over the place right now, there may be a case that just gets missed in the process. And so I've told them, if you see a case with somebody that you think is appropriate, please flag it and bring it to my attention. Honestly, our administrative staff at this point has gotten used to doing that for me as well. So they might have somebody call, even from out of state right now saying, I got arrested for, we have somebody that trespassed at the Amtrak station, there after hours and was asked to leave and refused to leave because they didn't want to miss the train, and they get arrested for it because they were a little bit belligerent. And they call and say, you know, I live out of state, I don't want to come because of COVID, I can't come because of COVID. Is there a way for me to talk about, you know, talk to somebody about my case ahead of time? And the admin will usually look through the case to see who the best person in the office is to talk to it about. If it's a domestic violence case, it goes to one person. And if it's something that they look at and say, this is a good ESI case, they'll flag it and bring it to my attention as well. And then in terms of whether I think we should go to a grand jury, I don't have enough experience with grand jury systems. I went to law school in Virginia and they do the grand jury, and I have a couple of friends that work as prosecutors down there. And they've kind of told me some horror stories about it, but I don't know if that's, you know, just them venting to me or if that's true horror stories. So I'm not really sure what that would look like more in practice. I just don't have enough experience with it.
Are there any other questions? If not, I'll thank Marissa. That was really a fascinating discussion. I really enjoyed it. Everybody's clapping.
Thank
We
you.
really appreciate having you. And I think everybody's off to Minion now, but thank you.
Thank you very much for having me. I appreciate it.
Thank you.
Thank you, Marissa.
Thank you, Marissa.
Of course.
Thanks, Marissa.
Marissa.